Anything you say can and will be used against you. Hey, Better, Richer, Stronger, Dental Nachos, all our friends. It is a beautiful Thursday afternoon at the Jersey Shore, and I have a very special guest here, my attorney, Rob Montgomery out of Philadelphia, who specializes in dental practices. Ladies and gentlemen, I have heard in the last couple of weeks some absolute horror stories about misunderstandings and all kinds of other crazy stuff that could be avoided if you have a gentleman like Rob working with you. Rob, I know you have one formal thing to say, but first of all, thank you for everything you do for me and for the profession, and thank you for being here.
Oh, thank you. It's always a pleasure, Alan. Thanks for having me today.
And the one caveat we've got to start out with is?
Of course, I'm a lawyer, so we're going to be talking about legal things today, I think, but understand that this discussion is for informational purposes only. You shouldn't construe this as legal advice. You know, if you've got a legal matter, you should seek counsel for your specific situation, your deal, your problem. But today, what we're talking about is just for everybody to learn a little bit more.
Yeah, and you know, Rob, it's not much different than what we do. If somebody pigeonholes us at a party and says, I got this tooth over here, what do you think I should do? And the answer is ask your dentist, for heaven's sake, and have him or her examine it. Right. Yeah, it's the same kind of thing. So this is not individual professional advice. This is an overview of what's going on in the dental world that intersects the legal world. And man, oh man, it could be really nice or it could be really ugly. Mm-hmm. Rob, in the last couple of weeks, a few wonderful dentists I've been working with have told me horror stories of needless nastiness and berating in the workplace, berating of a dentist's work by an employer dentist in front of a patient, in front of another team member. I've heard stories of sign-on bonuses being demanded back with interest. What do you do here? How do we avoid this insanity? And you can't give specific advice, but what do you tell people like this who come crying to you in distress?
Well, I mean, look, things can happen and surprises come up. You know, you can try to do all you can to protect yourself for the future, but that doesn't mean that there's not a possibility that something could go wrong. However, there are things that you can do to stack the deck. You know, it never ceases to amaze me how, you know, people will just sign contracts without having them reviewed, in some cases without even reviewing them themselves. You know, and I think it's important for young dentists to realize that, you know, you've made it through your life up until this point, really kind of never having to sign a contract that matters or that has variables in it. You know, like you sign a lease for an apartment, somewhat a standard realtor form. I mean, there's some things that you have to be aware of. You should always read that stuff, but you know, there's not a lot in there that could really undo your ability to earn a living, right? Or have an impact, long-term impact to your life. You're going to go lease a Toyota, same thing. You know, there's a 6-page leasing agreement that's has 3 columns and 4-point font. You know, like nobody, not even the craziest lawyer, Alan, sits in the car dealership and reads that agreement.
Yeah, but some crazy lawyer wrote it.
Yeah, exactly. Right. But happily, you know, some, you know, consumer group has vetted it, or, you know, it's made it through the regulatory process. There's not a lot in there that's going to be able to sting you. There's no ahas or gotchas. Mm-hmm. But now, really, for the first time in most people's lives, they are signing contracts that matter, that can be impactful. And you really have to realize, you have to really flip the switch and say, okay, I have to adopt a new mindset when it comes to agreements going forward, whether it's an associate agreement, a partnership agreement, an agreement to purchase a practice, a lease, whatever it may be. These agreements make a difference. They matter. And what's in them can vary wildly. So don't just assume that your friend signed an associate agreement and everything was fine and this is how it worked for them, and that you sign an associate agreement with a different practice in a different part of the country, and that somehow the same is going to apply to you. You have to be aware of what's in these contracts. You have to understand what they say. But then you also have to understand the implications of certain things. What if you have a non-compete that is 2 years and 20 miles? That means you're not going to be able to open up a practice. You're not going to be able to buy a practice or do a startup, regardless of what everybody on the Facebook group says, that don't worry, these things are not enforceable. BS, right? No bank is going to give you money to buy a practice or start up a practice in that restricted area, no matter how unreasonable they are. So understanding that, yes, if I sign this contract and I agree to this, this is what's going to happen. And then just understanding what you are required to do and what your employer is required to do. So you can really put yourself in a much better position if you take those steps. Now, that's not to say that you can't sign an agreement that's perfectly safe and that it's reasonable, and then start working for somebody who turns out to be a complete crackpot. That happens,
Yes.
right? But you certainly can mitigate a lot of risk. And certainly when you talk about things like sign-on bonuses and having to repay them with interest, I'm going to guess, Alan, that was in the contract. So when they got the money, they should have realized that that's what's going to happen and planned accordingly. It's not necessarily saying it's a bad thing, but you got to know what you sign yourself up for and be ready for when that day comes that this thing is going to be put to the test and pulled out of the cabinet and said, hey, you're leaving, you still owe us 6 more months. And here's what that means. I mean, that was agreed to at the outset. And if you didn't like it, you shouldn't have signed the agreement. If you don't like the 2-year, 20-mile non-compete, you shouldn't sign the agreement.
Yeah, the issue that my one friend has is that the ownership of the practice changed and the conditions that this individual was facing changed. And this person wants to get out very badly, but is stuck in, I think it's another year, another 8 to 12 months of this nonsense. The contract transferred over, the conditions of the practice changed. That's something that's, I don't know, I guess that happens now with acquisitions and mergers.
It does, and unfortunately, it's fairly standard for an agreement to say that it can be assignable to a purchase of a practice. But, depending on the situation and the reasons that the associate's taking the job, that's something you could try to negotiate. You're not going to be able to negotiate the non-compete or the assignability of the non-compete. So if somebody sells their practice, then the purchaser of that practice is going to have or should have the ability to enforce that non-compete. That'd be very difficult to get out of. But it wouldn't be unreasonable to say if the practice is sold, if the agreement is assigned, that the associate has the ability to terminate on 30 days notice if they don't want to work for this other group or this other practice owner.
This is where a dental specific attorney, oh my God, if I knew you 35 years ago, my first contract as an associate called for a partnership within 5 years. And 5 years down the road, here's the partnership. It's 5149.
Right. Not what you were thinking.
No. Well, that's why I'm here now in my own practice.
Right.
Other pitfalls that maybe you could talk about, that just a couple of little anecdotes of things that happen to well-intended associates and well-intended employers. But we employers make mistakes too.
Oh, yeah.
Anything come to mind?
Yeah. I mean, I think there are a lot of things. I mean, just say back up, just generally right now, we've really seen a change in the dental associate agreement marketplace, so to speak, and with the proliferation of DSOs and corporate owners, what used to be very folksy, sort of almost quasi handshake kind of arrangements have now turned into 20-page documents that are very technical and have all kinds of little potential traps in them. So it's really important, again, for the associate to understand what they're signing up for in those instances. And there's a lot of stuff in there that's just not good. And one of those themes that we're seeing that's becoming more popular is practices trying to hold people to a fixed term where they can't terminate, they can't leave without having to pay some sort of penalty. And that was the type of provision that I would see occasionally over the last 27 years I've been representing dentists. But once or twice a month, one comes into our office where somebody has one of those and the employer is trying to hold them to it, and it used to be, you would say, don't worry about it. Nobody's ever going to go after you for that. But now I can't say that anymore. So, the landscape has really changed. I think things that the associate needs to be careful about are, first and foremost, are restrictive covenants. I mean, this is, limiting your ability to practice your profession. So you've gone through all this education, spent all this money, and or taken on all this debt to become a licensed dentist. You guard that. That's an asset that you have, and it's something that you shouldn't just give up willy-nilly. So, sometimes restrictive covenants can be tricky to negotiate, especially non-competes. If you have a 10-mile non-compete and you say, well, I don't want a 10-mile non-compete, but I'd like a 7-mile non-compete. Well, a lot of practice owners are immediately, the antennas go up and say, oh, what she's planning on doing 7.2 miles away from my practice. But so that can be a difficult ask. Now, I mean, within reason. I mean, if you're in, North Jersey or, a densely populated area and somebody asks you for a 25-mile radius on a non-compete, that's crazy. Right?
Yes.
So, and frankly, a red flag with this particular employer. But things that are, I think, really fair game, if it's a group practice and it says that you can't work within 10 miles of any of their locations, and they have, 5 locations, and you're only going to work at one, why should you have to agree to restrict yourself from, essentially 1,600 square miles, right? That's nuts. I think it's reasonable then to say, I'll give you your 10 miles around this practice where I work, or if, be careful about a situation where the practice may have a satellite location where you go one day a month. Does that bring that into the calculus for determining whether or not, where you can and can't work? So it's just really, it's being careful with that stuff. I think the other thing that, people need to be aware of is if you're being paid on a percentage of collections, will you continue to get paid for money that comes in after you're no longer working for things that you did while you were working? Because if not, if you're working in a PPO practice and you don't get paid for anything that comes in, the day after you've left employment, then essentially that means that, you're not going to get paid for the last 2 months that you worked, so for the last 2 months, you've essentially are working for free, and so that's something that we see that comes up from time to time that you need to be careful about.
I've seen also in my dealing with our colleagues, withholding pay on work that supposedly the owner had to redo. Is there legitimacy to that, Rob?
I mean, I think there can be, if the concept is you completely screw something up professionally and we have to go and fix it and spend money on labs and, whatever it's going to cost us to redo it. Yes. But, do people abuse that sometimes? Yes. I frankly am not a big fan of provisions where the employer holds money that's due to the employee after they're no longer working there. I mean, I feel like, I'm an employer, Alan, just like you, I pay my people, that's it, and if we're going to have a problem, I'm going to have to address it with them. But, the whole concept, once you, as an employer, you start holding money that is due to an employee for work that they did, that's a tough one. And you better have
it's
a really
hard
good
to come after also, isn't it? It's very hard for an employee to go back and try and get that money, is it not?
It may be. Depends where you are. I mean, I think a lot of the overwhelming majority of states, with a very few exceptions, have laws that say that employers have to pay their employees.
Yeah.
And in many of these places, it's a summary criminal offense if they don't. So if the employer doesn't pay the employee, there's 2 routes in most places that the employee could go. They can go and hire a lawyer and spend money on a lawyer to chase after that money, which frankly, if it's $10,000, $10,000 is a lot of money. probably not enough money to warrant going out hiring a lawyer to chase after it. I mean, you could spend $11,000 recovering 10, which is not a good business decision. However, under most state statutes, the state also has the ability enforcement power, where the Department of Labor, or whatever they refer to it as in that state, has the ability to investigate and pursue these unpaid wages from the employer. And that doesn't cost the dentist anything. And frankly, can turn out to be a whole world of pain for the employer that has to go through that, because no business owner wants the government to come in and start looking under the rock. Okay. No matter how solid you are, no matter how well you dot your I's and cross your T's, you don't want a government investigator looking at your business and looking at your finances.
Yep.
Period. So that in and of itself can be a mechanism where, if people feel that they're not being treated fairly, there is another alternative, which is, hey, let's get the state to go after these people.
That's a tremendous word of caution to both employers and employees. Let's act above board, guys. Let's just act above board and move on. Rob, is there such a thing? I want to hire somebody. I want to write a contract. Can a dentist create a win-win? Do you see people not trying to hide anything? Do you see employers and employees sitting down together at the table and saying, all right, look, this is what works for me. This is what works for the associate. Rob Montgomery and associates put something together that works, and let's get it done. Does that happen?
Absolutely. I mean, and I think, it happens more in the owner operator world. As I said a few minutes ago, things have kind of changed in the dental contract landscape, where, owner operators are still kind of doing, for the most part, what they've always done. But, a lot of big groups and corporate owners aren't like that. And so the mentality with a lot of those groups who are represented by large and sophisticated law firms is, let's win the agreement. Let's win the associate agreement. Let's win the practice acquisition. And so as a result, they're wired in a way of, hey, I'm going to do what I need to do to stack the deck in favor of my client, to the detriment of the other side. In the owner operator world, where we all dwell in still happily, but there used to be, the vast majority of deals, overwhelmingly so, were owner operators. In that case, you're really looking at a transition, transitioning a practice and trying to work, collaboratively and cooperatively with the buyer and the seller, where, you don't want a winner and a loser when you're transitioning your practice.
Right.
You want the buyer to succeed. You want the seller to get what they wanted and ride off in the sunset. Like, that's a good thing. It's a harmonious relationship. Same thing with partnership agreements. If you want to, and that's probably even worse with partnership agreements, because there's an ongoing business relationship, which is, sure, you can stack the deck and again, and make it as favorable as possible for you, to the detriment of the other side. But, with most relationships, Alan, if there's a winner and a loser, it's just a matter of time until that relationship craters, whether it's, business partner, attorney client, a marriage, right? So, when one person's, when it's going great for one person and it's going really lousy for the other, eventually the person it's going lousy for wakes up and says, what am I doing in this? I want out. So, when it comes to associate agreements, it's kind of the same thing applies, where you've got, lawyers and parties who are really trying to stack the deck for those practice owners. And it's, to the detriment of the practicing dentist. And the difference is, Alan, in your practice, if you were to do that and really try to screw over the associate, you got to work with them every day. You got to see them, right? However, there's this other business model out there where the people putting the agreements together and the people who are in charge of all that are never going to set foot in the office. Right?
Yes.
It's a whole lot easier to say, hey, you know what? Too bad they don't like it. Right? Too bad they don't like it that they have to work there 8 more months and be miserable. They don't have to deal with that. I mean, if you had a miserable associate in your office for the next 8 months, you'd be trying to figure out a way to get them out right?
Yes.
Not chain them to the practice. So, I think it's, kind of overall, if you look at this from a more holistic standpoint, it's just really, as the associate, needs to just take into consideration not just the agreement, but the context in which the agreement is being delivered, who they're working for, the culture of the practice, the mindset of that practice, and then look at the agreement again and just understand kind of what they're signing themselves up for, and realize that a job is not a job, and they're all not the same. And they can vary very wildly depending on where they are, who the owner is, how many dentists are working in there, whether it's owned by a dentist, whether it's not owned by a dentist. There are a lot of variables that, if you go in with your eyes open, you'll see, but a lot of that is just, it comes down to awareness, Alan.
Yeah. Yeah. I think with the young dentists that I work with, it's, they're grabbing onto a job, they're grabbing onto a livelihood. They feel a sense of acceptance by an owner or an entity, and they don't look carefully enough as to what that entity is all about. Mm-hmm. And that happened to me. It had 40 years ago. It happens. And like you said, it's a lot tougher now. It's not simple now because they're not all owner operated practices.
Right. Right.
Can I indulge you for one more?
Absolutely.
Two great words: independent contractor.
Yep.
We both hang out on Dental Nachos and other sites, and we see this question coming up time and again. I know what the answer is, but I'm not a lawyer. But if I come to work for Rob Montgomery, DDS, as coming in Monday through Friday from 8 to 5, and Rob Montgomery, DDS, wants to classify me as an independent contractor, whether I'm a dentist or a hygienist, what kind of wonderful things happen with that?
Yeah, I mean, it's risky from the employer standpoint, because most of the time in that situation, the employer is misclassifying the employee as an independent contractor. And, they open themselves up to potential fines, penalties for failure withhold with the federal government. There are issues with the state government with unemployment. And then also there are issues with workers' compensation, whether or not they're paying into workers' comp for that employee, whether that employee is entitled to it. And these things, how do they come to light, Alan? Well, if you go and terminate this employee because they're doing a lousy job, and they go to file for unemployment, and the unemployment office says, you're not an employee, you're an independent contractor, you're not entitled to this. And they say, well, yeah, I've been working at this office from Monday to Friday, 8 to 5 for the last year. Well, yeah, but your employer hasn't been paying into the unemployment compensation fund. That's going to trigger an audit potentially. And now you've got a state agency looking under the rock. The employee gets hurt, and now there's a claim for against your practice. Is it a workers' comp claim? Do you have insurance for that? If not, the state could fine you for that as well. And the fines for that, depending on where you are, can be extraordinary. From the associate side, generally speaking, I mean, as an independent contractor means that you're going to be responsible for your share of FICA, Social Security and Medicare, which you would be as an employee, but then also the employer side. Yes. So basically right off the bat, you're looking at 7.5% or so of off the top that, you would not have otherwise had to pay. The other thing that you have to be careful about from an associate standpoint is, as we just talked about, that this could be risky for an employer because they could be open to fines and penalties. Sometimes independent contractor agreements will have provisions in there that says that the employee, or I should say the dentist, the contractor, as they're referred to in that independent contractor agreement, agrees to indemnify the employer for being misclassified. So if it was the employer's idea to do this, and now the associate is, quote unquote, indemnifying the employer for any fines or any damages that result from this misclassification, that means the employee, the young dentist, is becoming an insurer, essentially, of this bogus arrangement. So that if the government agency comes in and says, you violated, the law in treating this person as an independent contractor when they should have been an employee, here's a $25,000 penalty. it could be, if the agreement provides for indemnification, that the employer could then go after the employee and say, turns out it's 25 grand, we suffer loss. You agreed to indemnify us for this. Please pay $25,000.
Oh my goodness.
And I could tell you, there's only one time that I've seen that came to light in that bad way. But, Alan, it only takes one, and nobody wants to be that black swan. Yep. And so it can happen. And with a lot of these things, I'll just say that you look at these agreements and say, well, that probably will be okay, or that probably will never happen. Yeah, but after it happened, it happened. And nobody spends a whole lot of time talking about the odds of that happening. And gee, it was such a long shot. No, it doesn't matter. It's done. It happened, and it happened to you. You don't care if it was a 1 in 100 chance or a 90 in 100 chance. It doesn't matter. You now have to deal with it.
Yep. It's 100% when it applies to you.
Absolutely.
Yeah. Wow. That last one was an eye opener for me. I would never have thought of that. I think the point is you have to play by the rules, and you have to know what those rules are. And you have to, we're dentists, Rob. I know everything there is to know about dentistry. Everything. You come to me with a dental problem, there's nothing I can't solve. I know everything. But when it comes to the law, when it comes to finances, as we see, when it comes to so many other things, we're not doctors of that. And I think we have to come to some humble realization that our patients come to us because we know stuff that can help them that they don't. Hence the lawyer who knows stuff that could help us that we don't know. Yeah, it's so important. So Rob, we have met only by voice and in 2D. And we are going to get to shake hands, give a hug, and perhaps have a beer at Boost Camp, at Super Dentist Boost Camp next week with our friend Paul Goodman.
Yeah.
And I'm so looking forward to that. Guys, this gentleman is representing me on a number of things. He represents people I know, and the man knows what he's doing. I think the important thing to get out of this is, if you've got a question and you think you know the answer, you may not. And you really need a gentleman like Rob Montgomery and his people, or a lawyer, right? Any lawyer who specializes with dentistry is really an essential resource for all of us. Rob, how do we get in touch with you, please? Just in case anybody does have a need for a dental attorney.
Sure. The easiest way is to go to our website, yourdentallawyer.com. There's a portal there where you could submit questions. I think you can also click on our bios and get our email addresses, but definitely you have the ability to submit a question through a form, and somebody will get back to you usually within a day. And
I'll put that up. I'll put that up in the comments section on this interview.
Let me say this too, and also there we also we have other resources there. So podcasts that Paul and I do, but podcasts I've been on other shows, other people's podcasts. And we have other webinars and other content that we've put out. We put on our website that we feel would be helpful to dentists, and it's all free of charge, of course.
Yeah, these are such important things. Take advantage of this. These people know what they're doing. They've been around dentistry a long time, and they can answer questions that you can't answer. And with all respect to our other attorney colleagues, they've got knowledge that's just laser focused on the things we do and the crazy things that happen to us. I'll put the website link on this chat. And Rob, if I beg, will you come back and answer more questions sometime in the future?
Anytime. It's a pleasure, Alan. It's nice to see you in the 2D. And I do look forward to the 3D meeting with the beer.
You got it. Stay with me for just a moment, Rob. I just want to ask you something after we're done. Guys, I'll see you next week at Boost Camp. Please tell your friends, there are a ton of amazing educational opportunities coming up right here at Better, Richer, Stronger that nobody has done. Keep your eye on us. I'm going to be bringing people in that will give you knowledge and wisdom way beyond the operatory. I want to help. I want to give you stuff that I've learned the hard way that I could help you learn the easy way and develop yourself beautifully. So live well, live healthy, get some sleep, eat right, get some exercise every day. Make someone's life better each and every day you're out there, folks. And most importantly, enjoy the ride. I'll see you later. All right, I think we're done.